It is 11:30. My name is Jordan Walker with Seaver Walker Paget Law Firm. We're here to have our webinar on eminent domain and the Furr Road widening project. And with that being said, we are going to go ahead and jump in. Again, today we are presenting a North Carolina landowner eminent domain webinar. We're talking about the Furr Road widening project. Again, my name is Jordan Walker. I'm with Seaver Walker Paget Law Firm, and I'm here to talk about North Carolina law. What we'll be talking about today specifically, again, we'll be talking about the project. We'll be talking about eminent domain, but first I want to introduce myself a little bit more. Again, Jordan Walker with Seaver Walker Paget Law Firm. Seaver Walker Paget is an eminent domain only, landowner only law firm that has represented landowners across the country, including in North Carolina, among many other states. We have a combined over 70 years of experience in eminent domain cases representing landowners. We have represented hundreds of road project clients across the country, like I said, including in North Carolina. Consequently, we have accrued quite a bit of experience in eminent domain, and we are here to relay that experience and relay the law of North Carolina to you, the landowner. Again, we'll be talking about the project a little bit, and then we'll be talking about eminent domain, and then we will wrap it up. I suspect this should last about 15 minutes. So talking about the project specifically, this involves the widening of SR 73. This is actually part of three projects that encompass this 8.5-mile stretch of road between Lincoln and Mecklenburg, located in Lincoln and Mecklenburg counties. As you can see, it basically extends from 16 all the way to 77. The purpose of this project is to improve traffic carrying capacity within the area that allows it to maintain that capacity up into and through 2040. Additionally, there are going to be multimodal uses added to the road, including bicycle, pedestrian paths, et cetera, and so forth, which are fairly common in these types of projects. This project is not a new one. It has been going on for some time. As you can see here over to the right, it is a significant project. It's a $334 million project. Right away has been going on for multiple years, is our understanding. So we are in the thick of it, so to speak, with regards to right-of-way acquisition. So real quick, what is eminent domain and who can use it? Eminent domain is the generalized power of the government, broadly the government, although some private entities have eminent domain authority, in this case, the government, to seize private land and put it to a public use. So a lot of people don't know what eminent domain is, or they have some concept of what it is, and they don't really sure of what it is. Effectively, we have roads, we have public buildings, we have all sorts of governmentally owned land, and the way the government generally gets that land is through eminent domain. If NC-DOT or any entity wants to build a road, build a school, build a courthouse, build a firehouse, any sort of public use, they have the inherent ability to acquire private land and put it to that public use. So in this case, we're dealing with North Carolina Department of Transportation, other governmental agencies. They have this ability to take your land and put it to that public use. This is something that a lot of landowners find surprising and aren't really sure what to do. A lot of folks think it's unfair. The reality is that this is a feature of this country, of the state that you live in. Eminent domain is exercised across the country quite a bit. Obviously, to build roads, they need to get land, and this is how they do it. But regardless, there is a process set in place for these acquisitions, and we're going to talk about that. So while they have the ability to take it, they do have to follow certain procedures, and ultimately they have to pay for it. And it's not just that they have to provide some amount of money, but they have to provide what's called just compensation. And the overall conceit of just compensation is that the landowner is made whole because of the acquisition. So an acquisition is obviously taking land from you. In exchange for that, the DOT has to effectively make that landowner whole. And oftentimes that doesn't always end up being the case, and it's hard to define what makes a landowner whole because of this, but that is the overall goal, that the landowner is compensated not only for the acquisition, but for anything that the acquisition may cause as it pertains to the property itself, any value reduction, any impacts, so on and so forth. And we will get into that, but that's the overall goal, just compensation. It's supposed to be, of course, a just amount of money that properly compensates the landowner, not just simply compensates the landowner. So again, just compensation, it's defined as the fair market value for the acquisition of your property. Fair market value is, of course, determined by the market. Determining fair market value ultimately means determining what a willing buyer would pay a willing seller on the market. So that's the definition of willing buyer, willing seller. And the goal, again, of just compensation is to replicate a market transaction. These aren't market transactions. When a condemner takes property, that is not an open market acquisition. It is not a traditional arm's length transaction between private buyers and sellers. It is a acquisition with threat of eminent domain, which obviously introduces a whole other set of leverage to the acquirer. So those sales aren't considered arm's length; they aren't considered fair market value. But the goal of the court and the goal of the jury ultimately is to replicate what that market transaction would look like. It's sort of a hypothetical scenario because we're dealing with a situation that's not arm's length. So ultimately, determining fair market value, determining what a willing buyer and would pay a willing seller on the market for your property includes not only determining the value of the acquisition, that is what they want from you, but also any impacts that acquisition may have on the rest of the property. So both of these components are wrapped up in just compensation, and a landowner is entitled to both. So in North Carolina, the eminent domain process is fairly straightforward. There are, again, requirements that condemners must meet prior to filing their eminent domain lawsuit to acquire the land via the courts. So this is a generalized outline of the pre-suit and litigation process in North Carolina. The first beginning of the project, so to speak, would be it's obviously its conception. The idea for the project, of course, is this something the DOT wants to do? Is this have priority status, something that is necessary? Assuming it is something that they want to do and it is something that they like to pursue, there's obviously the engineering that needs to be performed on the project to determine where's the road going, what are they building, what is the nature of the project, so on and so forth. And then beyond that, many road projects are conceived and there are plans sitting out there that you yourself could probably find if you look for them. There's thousands of road projects that die at various stages of the project and don't ultimately get built. So just because a project is conceived, just because a project has the engineering behind it, they've done the maps, they've done the plans, that doesn't mean that the project will happen. Ultimately, what needs to happen, the most important part of a project to ensure that it gets built, is that funding is arranged. And this project specifically, funding has been arranged, which is why this presentation is relevant right now. So this project is beyond the engineering, it's beyond the funding stage. We are in right-of-way. We've been in right-of-way, which means that the right-of-way stage is acquiring land for the project. So individually for landowners, knowing that they have funding, knowing that this project is in the midst of happening, a landowner can expect, if they are affected in this project, eventually a compensation offer for their property. This offer is issued usually by contractors, third-party agents of the North Carolina Department of Transportation or the governmental agency that's acquiring. They'll issue the offer. At that point, this is an offer from them to acquire your property. They will deliver it to you. They will provide it to you. Once you get that offer, in the way we view it is that is you are effectively in the eminent domain process. You're not at court per se, but you are at the pre-court stage. So the preliminary stages of an eminent domain acquisition. So once you receive the offer, you have 30 days to respond. The landowner does have the right to reject this offer. A lot of landowners aren't aware that they do have the right to reject offers issued by condemners. You absolutely have the right to reject this offer. You do not have to accept it. Assuming a deal can't be reached pre-suit, assuming you've rejected this offer, eventually they need to get the land, and eventually they will file a condemnation lawsuit against you in the county where the property is located. So they'll file a lawsuit in Lincoln, Mecklenburg County. You will be served a summons of that lawsuit. And then at that point, you have 120 days from the point of service to file a response to the lawsuit. If you do not file a response, an appropriate response to the lawsuit within 120 days of service, your case will be over, and you will receive the deposit that's provided by the condemnor as compensation. You will not be able to contest that amount. That'll be the end of your case. You get what they determine it. So going backwards a little bit, you've rejected the offer. They filed their lawsuit in Mecklenburg County. When they do that, not only do they serve you with the lawsuit, but they also deposit their offer with the court. So they had this initial offer that was issued that you couldn't reach a deal. You rejected it. They went to eminent domain. As part of the lawsuit, they will deposit that offer with the court. So let's say you were offered $50,000. You are sued. NC goes ahead and deposits the $50,000 with the court. And in exchange for depositing that amount of money, that $50,000 with the court, the condemner takes immediate possession of the property. This is called quick take in other states. It's called quick take in North Carolina. Effectively, this is a fairly common procedure wherein across the country, and various states have procedures similar to this, wherein there's a preliminary amount, or there's preliminary access that is granted to the condemner to begin work on the project. Ultimately, while the just compensation is determined in the courts. So in this case, in North Carolina, they'll deposit that $50,000 with the court in exchange for that $50,000, which acts as a bond against that possession. It acts as a bond, and it grants them possession of the property to begin work on the project. Going back to the answer, we've been talking about just compensation a lot. If a landowner wishes to stop the taking, that is to say that they don't have the right to take the property, and they shouldn't be allowed to take the property, you must file those objections within that answer, also within the 120 days of being served. So after this process has been after you've been sued, after the deposit's been issued, what happens next? They've taken possession of the land. So assuming that the landowners filed a timely answer within 120 days, the court may appoint commissioners to determine preliminary just compensation. So the commissioner's purpose, again, this is another facet of North Carolina that's shared in many other states, whereas there is a preliminary just compensation amount that's determined either by the court, commissioners, you name it. There's various different processes and procedures, but in North Carolina, the court may appoint the commissioners to determine just compensation. So they'll go out, they'll do their own appraisal, they'll appraise the property, and they'll come up with their own amount, separate and apart from what the condemner, in this case, North Carolina Department of Transportation, determined it to be initially. So the commissioners go out, they do the appraisal. Let's say they come back and say, okay, you're actually entitled to $100,000, not the 50 that was offered initially. Well, at that point, either party may object, either the condemnor, which is the taker, NC, or the landowner. Either party can object to that commissioner's award. If neither party objects, then that amount becomes the final just compensation. So if the commissioner's award was $100,000, neither party objects, that's your compensation figure, case ends. If either party objects to that amount, the case continues towards a jury trial. Ultimately, you do have the right to a jury trial on just compensation in the state of North Carolina, but not every case reaches jury trial, even at this stage. Many cases will still resolve before getting to the jury trial. And a lot of times those cases resolve at a mediation, court-ordered mediation. Mediation is a formal settlement conference to attempt to resolve just compensation. It is not arbitration. Arbitration is a different process. It's basically a mini trial, or depending on how it's set up, an administrative trial, more or less. A mediation is basically showing up at a mediator's office and trying to work out a deal, separate and apart from the litigation process. It is usually court-ordered to alleviate cases that can otherwise be settled without needing a jury trial. Nonetheless, you're not compelled to settle at mediation. Neither party is compelled. It's just an opportunity to do so. Ultimately, if the case can't be resolved, you do have the right to a jury trial presented to a trial of your peers in the county where the property is located. And their duty, their task, is to determine just compensation. So talking about just compensation, I want to talk about some components of it. These are the types of just compensation, I guess, buckets that you can receive compensation for. You obviously receive compensation for value of the acquisition. What are they taking? They're taking an acre of your property. What is that acre worth? This can be determined by examining sales comparables of similarly situated properties. And it also can be determined by the income that the property itself is generating. But before you even do that, you first have to determine what the highest and best use of the property is. Highest and best use is an appraisal and legal term that basically means what is the highest and best use of the property that basically develops the highest economic return to the landowner based on the market. So as an example, if you have a property that's residentially used, it's used as a house, either as a rental or where you live, but that property is completely surrounded by commercial land and commercial property, and development has been moving in, and everything around it has been trending towards commercial development. In that scenario, for example, you could make an argument that your property, even though it's being used residentially, should be valued commercially. That is an example of utilizing highest and best use to your benefit. A lot goes into a highest and best use determination: zoning, again, trends. If you have offers from developers, that can be compelling evidence to acquire your property. That can definitely assist you in your highest and best use argument. So you are obviously entitled to the value of the acquisition, which is what we just discussed, but you're also further entitled to remainder damage if it is a partial taking. So meaning if they're only taking a portion of your property and they're leaving a remnant, there's a question as to how that remnant is affected by the partial acquisition. Remainder damage can be determined by any number of issues. Big issues we see that cause remainder damage: access changes, zoning noncompliance, if it causes your property to be noncompliant with local zoning ordinances. If it reduces your setback to a roadway, that can often result in a damage to the remainder. Parking elimination is a big one, of course, for commercial properties. Internal circuity issues, you can't get around the site anymore, that can be an issue. If it causes a weird shape, that can also be a cause as well. There's really any number of issues can cause remainder damage, and you are entitled to, well, not necessarily everything, but you are entitled to remainder damage, assuming that the damage is caused by something that is something you can recover compensation for. An example of not being able to recover compensation for something that's caused by the project would be a median. So, for example, if they installed a median out in front of your property that eliminated access going from one of the directions of the road, that is not a compensable taking. You are not You cannot receive compensation for median installations. That's a fairly consistent rule across states. And that is one example where you don't just get what you want. There are some limits, and you should discuss that with your counsel. And then if you have a total taking that's taking the entirety of the property, you're further entitled to relocation expenses, assuming there is a residence or a business on the property. So if you have a house, if you live there and they're taking your house, you have the right to relocation benefits. You have the right to relocate your house to a new location. Obviously, if they're taking your house, you'll need a new one, and that's the same with the business as well. They will offer relocation expenses for total takings, which you yourself can evaluate, just like you can evaluate the just compensation offer. And I want to talk about your rights as a landowner, and we are getting close to the end. Thanks for sticking with us. Your rights when you receive an offer. You have the right to reject the offer. You do not need to accept the offer that is issued by the NC Department of Transportation. You have the right to secure counsel. You have the right to secure your own expert testimony, your own expert reports. You have the right to contest compensation at court. You have the right to contest the right to take at court. I will say that contesting the right to acquire land is very difficult. It's a very tough argument to make. It is very fact specific, and there's a lot of deference given to condemners and DOTs in these acquisition projects. So assuming they don't follow the law, or if they don't follow the law, that might be a grounds to object. But by and large, if they follow the law in their pre-condemnation procedure, especially for a road project, it's going to be very difficult to stop that acquisition on your property. You do have the right to a jury trial over just compensation. That's the final right we have. Okay, so this is my final slide, and then we will open up for questions if there are any. I want to talk about getting attorneys involved because a lot of folks end up hiring counsel on these cases. For folks that don't have a lot of experience hiring attorneys, especially eminent domain attorneys, I wanted to talk about how eminent domain attorneys are generally paid in these scenarios. So if that is something you do, you're aware. These are the general agreements that we've seen from eminent domain attorneys out in the field, agreements they've arranged with their clients. In our experience, most eminent domain attorneys work on a contingency fee, wherein they collect their fee is some percentage of the total compensation amount or the amount added to the case over and above the initial offer. So in contingency fee agreement arrangements with attorneys, the attorney generally doesn't get paid until the end of the case. They get paid, again, some percentage of the amount that they've added to the case or over some percentage of the gross settlement. Some benefits of a contingency fee agreement for landowners: it allows landowners generally to hire attorneys without coming out of pocket. Generally, contingency fee attorneys just take the case on, and their fee is just whatever they get at the end. So since it comes out at the end, it doesn't require the landowner to come out of pocket up front. Beyond that, it may provide peace of mind to landowners with regards to what their attorney is doing and the goals and the motives of the attorney. If an attorney is operating on a contingency fee and their fee is contingent on how much more they get for you, then for some landowners that provides some security that whatever the attorney is doing is on their behalf, because it's also presumably being done on the attorney's behalf as well. For some landowners, they see this as a financial motivation it's obviously a financial motivation, but this can provide landowners with some peace of mind that whatever their attorney is doing, of course, working on their behalf, they are doing it for themselves. Because again, assuming the attorney has a financial motive, they're all on the same page. They're all invested in the same goal. There are of course many different attorney-client relationships that can be created, and these are certainly not the only ones. These are just the ones we see the most with eminent domain attorneys. The other one that we see a lot is an hourly or retainer agreement, although we see this much less, where this is a more traditional arrangement with an attorney where the attorney charges an hourly fee or a flat rate to handle the case. So they'll charge their billable rate, whatever their billable rate per hour is, or they will ask for a flat rate fee, some amount of money to handle the entirety of the case. This may require an upfront retainer that the attorney would then bill against. So, for example, if some attorneys may require an upfront retainer, let's call it $5,000, to basically as an upfront amount of money that the attorney then bills against. So if you have a $5,000 retainer and the attorney bills at $5,000 an hour, you effectively have 10 hours of the attorney's work before that retainer expires, or there's no money left. It sometimes needs to be replenished by the landowner. It would depend on the agreement, of course. So that's an example. The benefits of hourly and retainer agreements is that it allows landowners more certainty in what their fees are going to be. Ultimately, it's just however much time the landowner or the attorney puts in. You can instruct the attorney not to do certain things if you don't want to pay for them, pay for the attorney to do that. But ultimately the benefit of an hourly retainer, and then oftentimes that's just how some entities prefer their agreements with attorneys. A lot of companies, usually larger ones, prefer to have a standard hourly rate just for consistency and understanding what is being billed and what they're paying for. So there are many, of course, again, these are not the only two types of attorney-client relationships, contract relationships, and eminent domain, but these are the two that we see the most. So with that being said, I will go ahead and end this presentation, and I will open it up for questions.